Nina Morrison, I'm glad that you're sitting there, and I'm glad that you're being considered for this. You know the line of questions that you will face. Like every human endeavor, our system of justice is less than perfect. We know that innocent Americans have been wrongly convicted. Some have been wrongly executed. The Innocence Project, which you are an integral part, is an organization which I know personally from my state of Illinois and my hometown of Springfield. It leads in the effort to make sure that the cause of justice is served. Innocent people are exonerated, and the truly guilty are found and held responsible. But of course, it raises the question about whether you can be objective and follow the law when it's inconsistent with some of your previous experiences. So how do you answer that?
Thank you, Chair Durbin, for that question. I have been so fortunate to work at the Innocence Project for the last 20 years in my role as an advocate. And I think if I'm lucky enough to be confirmed, I would take as a model the many judges who I've appeared before across the country, often elected from both Republican and Democratic tickets, many of whom had backgrounds very different from mine as prosecutors or from the private sector, but who gave me a fair hearing, who listened to my arguments and followed the law. Were it not for those judges, many of my clients would not be free today, and I will take the memory of those appearances with me if I'm fortunate enough to be confirmed.
Let me ask you about the death penalty. I'm a sponsor of a bill to abolish the federal death penalty. I won't give a speech on it. But the question is, if you are chosen to be a federal judge and face a set of facts and allegations that lead you to believe that a person might be eligible for the death penalty, would you have any hesitancy or second thoughts about imposing it?
Thank you, Senator, and no, I would not. The Supreme Court has repeatedly held that the death penalty is constitutional. That puts it into the hands of policymakers like yourself and prosecutors and the citizens who elect them to decide if it should be available as an appropriate punishment for crime. Of course, no one wants an innocent person executed, but the work that I have done over the last 20 years has been in the role as an advocate. The role of a judge is very different, which is simply to ensure that any proceedings before you are constitutional and follow the law, and it would be my honor and my privilege to serve in that role.
Thank you.
Over the past few years, you praised progressive prosecutors like Rachel Rollins and Larry Krasner for their intent to, quote, reform current tough-on-crime practices, end of quote. You've written that the American criminal legal system has done, quote, decades of damage to communities, and you have suggested that the criminal justice system suffers from, quote, unquote, systemic defects. Given your substantial criticism of our judicial system, how would you plan to use your position as a district court judge to change the system if you're confirmed?
Thank you, Ranking Member Grassley, for that question. I don't recall some of the specific remarks that you referenced, but I certainly have spoken and written about the role that prosecutors can play in the work that I do, which is rectifying wrongful convictions. Typically, the cases that I work on with prosecutors are decades old. Sometimes the prosecutors who handle them were in law school or in high school when the cases were originally prosecuted. And I am grateful to many of them from both political parties and all around the country for working with me to do justice and to use DNA and other evidence that wasn't previously available to free my clients. My role as a judge would be very different if I am confirmed. It would simply be to preside over each case one at a time and to decide the law based on the facts presented to me.
For you also, you have been politically active throughout your life as a volunteer, advisor, and activist, and I can't find any fault with that. You have also said that, quote, a way to be a good citizen is to be politically active, end of quote. How has your political activity shaped your view of the law and the Constitution?
Thank you, Ranking Member Durbin. As I referenced in my opening, my grandfather came to this country when he was 4 years old, and I was his first grandchild, and we talked a lot about the privileges and responsibilities of citizenship. He came from a country that was not free, as America is. And I have volunteered on political campaigns when I've had the time as part of my duties as a citizen, but I recognize that the role of a judge is entirely different, and I certainly would abide by all of the canons of ethics and limit or stop my political activities in that.
Okay. Do you think it's appropriate for a district attorney to decide to ignore criminal statutes and not to prosecute an entire line of cases?
Thank you, Senator, for that question.
You're welcome.
District attorneys, as you know, are accountable to the people and the citizens who elect them. And I know it has become an issue in elections about the extent to which district attorneys will use the resources of their office to focus on particular
Yes, ma'am.
categories.
And what do you think about that issue? Do you think it's, let me ask you again, do you think it's appropriate for prosecutors to say, I disagree with the legislature and the people, and I'm not going to prosecute an entire line of cases?
Senator, I think it is appropriate for prosecutors to evaluate each case that comes before them, and almost
Yes,
every
ma'am, but
prosecutor.
that's not what I'm asking. I know you, I mean, you're smart, okay? I can tell from your resume. Let me say it again. The people elect their legislators. Legislators say on behalf of the people, this is a crime which society will not tolerate without punishment. Do you think that it's okay for prosecutors to say, I disagree and I'm not going to prosecute an entire line of cases, I don't care who is charged? Do you agree with that?
Senator, I agree that prosecutors have the legal option to use the flexibility
No,
given
but
to them.
when they exercise that option, do you agree with that?
I think it would depend on the circumstance under which they're exercising it and what the rationale was for their
Well, what are the circumstances where it's okay to do that?
So I think prosecutors in this country work very difficult jobs under very demanding conditions.
I'll stipulate to that, but we have prosecutors who are saying, to hell with the legislature and the people, we're not going to prosecute an entire line of cases. And I think my question is pretty straightforward. Do you agree with that or disagree with it?
Senator, I have never worked as a prosecutor. I have.
Yes, ma'am, but you've read about it.
Yes, sir.
What's going on? Do you agree with it or disagree with it?
Senator, I don't think I can give a categorical yes or no to that because I think it would
I think
depend
you
on
just
the
answered my
circumstance.
question. What do you think about the job being done by District Attorney Krasner? I believe you worked for the District Attorney's re-election or election. Do you think he's doing a good job or a bad job?
Senator, I did not actually work on District Attorney Krasner's campaign. I've been an
Okay.
adversary of
I
that office.
apologize. Do you think he's doing a good job or a bad job?
Senator, I don't think it would be appropriate as a judicial nominee for me to comment on the performance of an elected official.
Why not?
Because there is always a chance that a case could come before me in which someone has, say, a prior conviction from Philadelphia who's then prosecuted in New York, and any commentary that I made on that office could be grounds for...
Isn't that convenient? Do you think judges, apparently you think that prosecutors should be able to say, we're not going to prosecute a line of cases and a group of crimes despite the solemn expression of a legislative will? Do you think judges should be able to do that? Say, I don't agree with this criminal statute, I'm not going to prosecute, I'm not going to hear cases for any of them.
No, Senator, judges do not prosecute cases, and
I know that, but do you think a judge should say, I don't want to hear, I'm going to dismiss all these cases because I don't agree with the criminal statute? I think you understand my question, Ms. Morrison.
I do, Senator, and I would, I'm trying to recall how you phrased the question. I would agree with you, or at least my position would be that judges cannot refuse to adjudicate or hear a case and ignore the will of the
But
legislature.
district attorneys can.
As executives, they are granted with greater discretion. For example, district attorneys day in and day out
A whole
receive
line of cases.
complaints from the police that they then evaluate based on the evidence.
Do you
and
think a
decide
district
process.
attorney, it's appropriate for a district attorney saying, look, in the name of social justice, I'm not going to prosecute armed robberies anymore? You agree with that?
Senator, I would stand on my previous answer. I think it would depend on the circumstance. I'm not aware of any district attorney in the country that
How
has
can I
said.
vote for you if you won't answer a straightforward question like that, Counselor?
Senator, I would hope that you would consider the entirety of my record and my qualifications and the work that I've
The
done.
problem is I have. And I see all these comments you've made in favor of the district attorneys who, in the name of social justice, and you've spoken glowingly of all of them, and now you won't answer my question about it. You say it's inappropriate. And I think it's really appropriate. Thank you, Mr. Chairman.
Thank you, Senator Kennedy. Senator Cruz?
Thank you, Mr. Chairman. Ms. Morrison, you urge this committee to look at the whole of your record. I will confess the whole of your record is deeply disturbing. Across this country, Americans are horrified at skyrocketing crime rates, at skyrocketing homicide rates, at skyrocketing burglary rates, at skyrocketing carjacking rates. And all of those are the direct result of the policies you've spent your entire lifetime advocating. You have repeatedly praised steps the new, quote, progressive prosecutors have taken, refusing to prosecute violent crime and letting violent criminals go. And as a result, far too many innocent people have died. Now, just a minute ago, you gave Senator Kennedy a very lawyerly answer. He asked you about Larry Krasner, the elected district attorney of Philadelphia, and I listened very carefully to your answer. You said, Senator, I didn't work on his campaign. Well, Ms. Morrison, that answer is technically right, but I assume you read the questionnaire you submitted to this committee, and on this committee, you identified yourself as an advisor to his transition committee. So you may not have worked on his campaign, but you advised him in his transition committee. For those who don't know, Larry Krasner was elected district attorney in Philadelphia. He was backed by George Soros, who has backed prosecutors across the country releasing violent criminals. According to the Philadelphia Inquirer, upon taking office, Krasner immediately fired 31 veteran prosecutors. An additional 39 veterans of the office resigned in the years following. Now it's reported that over 60% of the office consists of less experienced junior attorneys with less than 4 years' experience. Ms. Morrison, is Philadelphia today more safe or less safe than when Mr. Krasner became district attorney?
Thank you, Senator, for that question, and I apologize if my answer to Senator Kennedy's question was in any way misleading. I certainly did serve as an advisor to District Attorney Krasner.
Okay, good. Let's talk about, is Philadelphia more safe today than it was before he was elected?
The issue on which I worked specifically...
I have a specific question. Is Philadelphia more safe today than when he was elected?
Senator, respectfully, I have not...
That's a yes or no?
I do not consider myself an expert on crime statistics.
You have no
and
view?
safety. On Philadelphia, I can certainly talk about the cases that I've worked on in Philadelphia.
So you advise this transition team. Let me ask you, when you were advising him on his, and by the way, is the murder rate today in Philadelphia higher or lower than when Mr. Krasner was elected?
Senator, I do not know because I have not studied those statistics.
So you were part of the transition team but didn't really care about the results. Well, let me answer it for you. When Mr. Krasner became district attorney, there were 315 homicides citywide. How many do you think there are this past year?
I know the murder rate is up nationally, Senator, but I'm not familiar with the specifics.
It went from 315 to 562, almost twice the 2017 number, the highest in over 60 years. Let me ask you, is that a progressive approach? You call these progressive prosecutors who let violent criminals go, who then murder innocent people. Is that progressive? 562 people murdered in Philadelphia.
Senator, I take a strong interest in the successful prosecution of murder cases because...
Okay, I actually don't believe your record reflects that, so let's look elsewhere, because you actually make a business of supporting these soft-on-crime prosecutors that release violent criminals. You also were on the transition committee for Los Angeles District Attorney George Gascon, who came to office in 2020. Like Krasner, like other Soros DAs, they come in to let violent criminals go, and they do it. And those violent criminals murder innocent people. Do you have any idea what the murder rate was in Los Angeles County in 2021?
Senator, again, I'm aware in the wake of the COVID pandemic, the murder rate is up nationally, and I don't know the specifics.
So you serve on transition teams for DAs, but you're not concerned with the murder rate. Well, it's 397 murders in 2021. That was 11.8% higher than the year before, which was 355, and it was 53.9% higher than the 2019 total before Mr. Gascon was elected. That was 258. Why is it that you keep being part of the transition team, helping advise district attorneys on how to release violent criminals, and you're the head of the Innocence Project? The Innocence Project actually does good work for people who are wrongfully convicted. They should be released. But do you care about the innocent people who are murdered because you keep advising people who put policies in place that result in more innocent people being murdered?
I see the time is up, but I'm happy to answer the senator's question if the chair will permit. Senator Cruz, I have worked for 20 years on cases involving some of the most horrific crimes imaginable, murders and rapes. Some of my own clients were murder victims' family members. They lost their loved ones and were wrongly convicted of killing them. And much of the work that I have done with DNA and other evidence has helped identify.
Ms. Morrison, you're not answering my question. Why do you keep advising radical district attorneys who let violent criminals go and result in homicide rates skyrocketing? Do you care about the innocent people being killed because of the policies you're implementing?
Absolutely, Senator. And to clarify, my role in those transition committees were only on the issue of what's called conviction integrity, not the front-end prosecution policies, but on the review of old cases. That is the limited capacity on which I worked. I played no role in formulating the front-end policies, but it is because when the wrong person is convicted of murder, the person who's actually committed the crime isn't brought to justice, that I think the work connects.
Sadly, your nomination is part of a pattern from this administration, and Democrats in the Senate, if they follow their pattern, will vote to convict yet another judge who will let more violent criminals go.
Mr. Chairman, may I ask you a question?
Of course, Senator Kennedy.
Are these witnesses under oath?
Well, sure, you know that.
Okay. No, I didn't see you swear them in.
I did. I promise you I did.
I'm sorry, I missed that.
Senator Lee?
Thank you very much, Mr. Chairman. I've got a list in front of me of the charges for which the default for Rachel Rollins was to not charge. Trespassing, shoplifting, larceny under $250, disorderly conduct, disturbing the peace, receiving stolen property, minor driving offenses, breaking and entering, wanton and malicious destruction of property, threats excluding domestic violence, minor in possession of alcohol, drug possession with intent to distribute, a standalone resisting arrest charge combined with only charges that fall under the list of other charges declining to prosecute. Not all of those are charges that, as to which the failure to bring charges would be a problem in a particular case with particular circumstances. A decision up front not to bring charges when accusations come up like that is a problem. And so your support of this approach is deeply concerning to me. I mean, these are things that in many instances are themselves violent acts. Breaking and entering is a violent act. You've got to break in order to enter, and it's also the type of offense that inevitably, by virtue of the way it's committed, leads to violence. Would you agree with that?
Senator, I absolutely agree that breaking and entering under certain statutes is a violent act and certainly could lead to violence, and I've seen that in my cases as well, sir.
Okay, so that concerns me. Your support of this approach and of Rachel Rollins is deeply concerning to me. It's also concerning to me. I've been looking at this piece you wrote about 3.5 years ago in the New York Times, in which you refer to the fact that you say prosecutorial misconduct taints thousands of cases. I don't see any empirical support for that. Can you give me parameters around that? Are you talking about in the history of time since 1791? Or, talking about in New York in the entire country? What does that mean? Thousands of cases over what time period and in what jurisdiction?
Thank you, Senator Lee, for that question. The piece that you're referring to, I believe, was an op-ed I wrote for the New York Times about prosecutorial accountability and prosecutorial discipline. I don't remember the specific quotation that you're referring to, but I can tell you that there are some reliable estimates from the National Registry of Exonerations, which is a project of the University of California, Irvine, and the University of Michigan, that has systematically reviewed proven wrongful convictions reversed by the courts that involve prosecutorial misconduct. And so based on that particular study, as
Okay,
well as some
but
others-
again, over what time and in what jurisdiction? If it's boundless, if you're talking about the entire country, the entire history of the country, I don't doubt that. If you're talking about a specific year and or a particular jurisdiction, I find it troubling that you'd throw that in there without defining it. I assume you would agree with me that it's a bad thing to sow seeds of distrust in the criminal justice system unless you're ready to back them up.
I would agree with that, Senator.
And don't you think that raises that concern if you're saying thousands, prosecutorial misconduct taints thousands of cases? You can understand how a reader of the New York Times or any other publication, if they just read that in context, could think that you mean thousands of cases per year in the state of New York, which, if true, would be a significant thing, and if true, would also be something that you would need to prove or establish. If not true, and people had that impression, what effect do you think that might have on people's respect for law enforcement?
Thank you, Senator. The piece of which you're referring, I think, if I recall correctly, made clear that cases of prosecutorial misconduct are a very small percentage of cases prosecuted nationally. The thousands represent fewer than 0.1% or even less of all the cases prosecuted.
Yeah, but you're assuming that you know the numerator and the denominator. I don't know how you make that claim. If you say that they prosecute, what did you say, less than 0.1% of all instances of prosecutorial misconduct. How do you know that? Your microphone's not on.
My apologies. Senator, again, the space constraints in that op-ed did not permit me to list all the sourcing, but there are a number of studies along those lines. And the big picture question that you're asking is, I think, when our system responds to the very small number of cases involving misconduct, it builds trust in the justice system because of the importance of getting it right. And I am proud to have worked with many prosecutors from all political parties and all ideologies who have taken it upon themselves to improve the justice system. In particular, in Senator Cruz's home state of Texas, there was a law passed in the name of one of my former clients to try to make it easier for the wrongly accused to get access to exculpatory evidence because of proven misconduct in that case, and it was unanimously passed by a primarily Republican legislature.
Okay. I don't dispute, and I'm wrapping up, Mr. Chairman, I don't dispute that prosecutorial misconduct is a serious thing, that it happens, that it needs to be taken seriously, that it's unacceptable when it does happen. It does concern me when people throw out broad statements like this without backing them up, without defining them jurisdictionally or temporally. And that coupled with your support of Rachel Rollins and her approach has me very concerned that as a life-tenured Article III judge, if confirmed, you'd be dealing with these cases every day, many times each day. If you take an approach that starts from the default proposition that the system is bad and that a lot of these charges should not even be brought, that's deeply troubling to me. Thank you, Mr. Chairman.
We now have in order Senator Blumenthal, Hawley, Padilla, and Durbin. And a message from God. We'll start with Senator Blumenthal.
Thank you, Mr. Chairman. Ms. Morrison, would you begin with a view that prosecutors are bad and their cases are riddled with error as a default position, as Senator Lee has just suggested?
No, Senator, and in fact, I would estimate that about 1/3 to 1/2 of my clients who've been freed through DNA and other evidence would not be free today were it not for conscientious prosecutors around the country who worked with me to uncover the truth. And I am very proud of my working relationships with them, and I think the trust that we've collectively built into the system as a result.
I was a prosecutor in a former life, a federal prosecutor, and then I was state attorney general for 20 years. And I will tell you, and I think most prosecutors feel the same way, nothing outraged me more than prosecutorial misconduct. Nothing was more debilitating and degrading to our system of justice than a federal or a state prosecutor purposefully doing injustice. And I would hope that my colleagues on the dais would agree. And the reason is quite simply, there's an added responsibility on the part of a prosecutor to make sure that justice is done, win or lose. I think it was Justice Jackson who said something like, a prosecutor wins when justice is done. Not necessarily with a conviction, but when justice is done. And I assume you would agree with that basic sentiment.
I do, Senator.
And let me ask you, in assisting prosecutors' office, what did you view your role as being? What was your service to them?
Thank you, Senator. So I have one particular area of expertise that I've developed in my 20 years at the Innocence Project, among some related areas, but primarily it's the reinvestigation of old cases, specifically from a time when DNA evidence was not available. So I have trained prosecutors in the responsible use of forensic science, in a practice of jointly reinvestigate cases called conviction integrity reviews, where we put aside the adversarial model and go back and interview witnesses together, share files and information, and it's a truly collaborative effort. I have also done some training on discovery practices, which is the practice through which prosecutors fulfill their constitutional duty to provide evidence favorable to the accused. I have not been involved in shaping front-end policies in misdemeanor cases or lower-level felonies for today's prosecutors, though I'm aware that that's the subject of much debate.
Would it be fair to say that you try to inculcate or give guidance as to how to review cases to assure that justice was done in particular cases?
That's correct, Senator. And I should also add that I have been occasionally involved, though not as an advocate, but to assist prosecutors in the re-prosecution of old cases. So in a number of our cases, the DNA evidence that we uncovered was able to identify the person who actually committed the crime. And so I have provided copies of my files or records or factual information to assist in the re-prosecution, resulting in some of those individuals now currently serving life sentences for murder cases and related matters.
We've been talking, I think, today about a December 2019 article that you wrote, an opinion piece entitled "Prosecutors Can Right Past Wrongs If Only the System Lets Them." I assume you remember that piece, just a couple of years ago.
Yes, I was a co-author of that piece, Senator.
In that piece, you praised, and I'm quoting you now, a growing cohort of prosecutors seeking a new approach to justice. And then you go on to describe those prosecutors as seeking to, and I'm quoting you again, reform current tough-on-crime practices, and, still quoting you, restore trust in the criminal legal system as a whole. I want to talk to you about your view on tough-on-crime practices and why you're opposed to them. Just a few things to make sure that we're on a level set here. Are you familiar with the fact that homicides were up 30% from 2020 to 2021 in this country, the largest increase ever recorded in American history?
Senator, I don't know that I can vouch for that precise statistic, but I am aware that there are some studies showing that homicides are up across the country.
In 2020, St. Louis, in my home state, saw its highest murder rate in 50 years. Carjackings were up in D.C., to take another example, from 142 in 2019 to 426 last year. Carjackings quadrupled in Philadelphia since 2015. In Chicago, they're up from 303 in 2014 to 1,800 last year. They're also skyrocketing in St. Louis County, and St. Charles County, in my home state, all in the greater St. Louis area. And these are just a few of the statistics that show the dramatic increase in crime, in violent crime, in assaults, all across this country. You praise in your piece where you decry a tough on crime practice, you praise someone, a prosecutor in my state in particular, St. Louis Circuit Attorney Kim Gardner. Do you remember praising her in this piece?
Thank you, Senator Hawley. Yes, the focus of that piece and the specific aspect of Ms. Gardner's work that we were discussing was her work on a murder case that long predated her tenure, in which she found evidence that the person was actually innocent and had gone to court to try to overturn that conviction.
Well, you praise her as the St. Louis Circuit Attorney, so let's just talk a little bit about her record that you saw fit to praise. In 2020, in the midst of rioting that convulsed the city of St. Louis, police officers were shot at. A retired police captain, David Dorn, was murdered. Rioters threw rocks and gasoline and frozen water bottles at police officers. Firefighters were assaulted and blocked from responding to fires that looters set across the city. Businesses were burned, their windows shattered. Innocent civilians were assaulted. The police, over the course of 2 nights of rioting, arrested 36 separate individuals. They sent them to the prosecutor's office, the one that you praise, Kim Gardner, as a model. And do you know how many of those 36 that she prosecuted?
I do not, Senator.
No, the answer is 0. She released all 36. I've got the news articles right here. Circuit Attorney Kim Gardner says that, in fact, she confirmed 36 people arrested Sunday and Monday night for rioting and looting have all been released from custody. What Kim Gardner did instead is blame the police. She said that the police were the ones at fault. The police hadn't given her the evidence. The police hadn't provided what she was seeking. This is her quote: "We need essential evidence from the police." This despite the fact that the police confirmed they had brought these people who were arrested in the course of doing the things I just described: assaulting police officers, throwing rocks and gasoline and frozen water bottles, assaulting firefighters, burning businesses. And she didn't charge any. 36 people arrested, brought to her, evidence presented to her, and she releases them. Now, is that the kind of approach that you stand by and think is appropriate for prosecutors to take?
Senator Hawley, the focus of the piece in which I mentioned Ms. Gardner that you're referencing was the case of a man named Lamar Johnson. And what I found particularly heartening about the events that took place after we wrote that essay is that the Missouri legislature, I believe Republican in both chambers who sponsored the bill, changed the law so that Ms. Gardner could successfully file a motion for a new trial on behalf of the individual referenced. And we were joined by the Cato Institute and others in supporting that bill. So I agree with you. There are many issues of great public debate about how we should best oppose crime and public safety. But in the particular case I was writing about, it appeared to reflect a broader consensus about how to handle wrongful convictions.
But that, with all due respect, that's not how you describe her in this piece. You describe her as part of a cohort of prosecutors who seek a new approach to justice, and in particular seek to reform current tough-on-crime practices. Now, I do agree with that characterization. I think you accurately have described the behavior of prosecutors in my state. They have reformed tough-on-crime practices. In fact, I'd say they're pro-crime. They're pro-criminal practices, and we're seeing the result of those in my state. And unfortunately, the result is people who are the most vulnerable, people who can't afford private security, people who aren't connected and wealthy, they're the ones who suffer. They're the ones whose children aren't safe. They're the ones whose cars are smashed. They're the ones whose businesses get looted. They're the ones whose neighborhoods you can't go out and walk on the street. And they're suffering right now in my state and all across this country because prosecutors won't do their job. You praise these prosecutors as taking a new approach, and I agree with you. It is a new approach, but it's a disastrous approach. And unfortunately, for that reason alone, I cannot support your nomination, and I will not support the nominations of judges or any other individuals sent to us by this administration who are soft on crime and soft on criminals. Frankly, it is a pattern with this administration, and it is one that has got to end. And for those reasons, I will oppose you and anybody else that the president sends up to us who does not understand the necessity of the rule of law. Thank you, Mr. Chairman.
Ms. Morrison, in 1993, a serial rapist and murderer named Liddell Lee entered the home of Deborah Reese, a newlywed and a mother of a 7-year-old in Jacksonville, Arkansas. He beat her 36 times with a tire thumper, and then he finished the job by strangling her to death. 2 years later, he was convicted by a jury and sentenced to death based on eyewitness testimony and his possession of her stolen property. After his arrest, he was also connected to other crimes, and he was convicted of 2 rapes, charged in 2 more rapes, and another murder. The prosecutors decided against pursuing that additional murder charge since he was already sentenced to death. After more than 20 years, including numerous frivolous appeals and motions for delay, Lee was finally brought to justice in 2017 when his death sentence was carried out with approval from the Supreme Court. You accused Arkansas of, quote, rushing through the execution, even though it had taken 20 years at that point, and you tried to get even more delay. And even after Lee was executed, you continued to try to cast doubt on his guilt with new DNA tests, which proved inconclusive. Do you believe that Liddell Lee committed the rapes and murders he was accused and convicted of committing?
Thank you, Senator Cotton. As you indicated, I became co-counsel for Mr. Lee about 2 weeks prior to his execution at the request of some Arkansas attorneys who wanted me to evaluate a claim for DNA evidence that had never been litigated in the courts. None of Mr. Lee's prior attorneys before his execution date was set had ever asked the court to allow post-conviction DNA testing, even though your home state has a law which provides for it. And in fact, one of Mr. Lee's attorneys later admitted that he suffered from a serious alcohol and drug problem and did not provide Mr. Lee with the representation that he was constitutionally entitled to. So I was involved simply in his request for DNA testing. As you know, we were unsuccessful. After Mr. Lee was executed, I became the lawyer along with several others for his surviving sister, who wanted to uncover the truth and see if her brother had been executed for a crime he didn't commit. As you indicated, we then went to court and actually got the agreement of Jacksonville, Arkansas officials to test the DNA in that case. Some of the results were inconclusive, but notably there was male DNA on the murder weapon that did not come from Mr. Lee, which was the weapon that had been used to murder Ms. Reese. It does remain an open investigation, and I continue to represent Mr. Lee's sister, so I'm afraid I cannot comment on the merits of the case, but that is the history and my role.
So you said, as recently as last May, 9 months ago, that those DNA tests were incomplete and partial, as they had always been. And he was not convicted at any point on the basis of DNA evidence. He was convicted on the basis of eyewitness testimony and his possession of Ms. Reese's stolen property. So I will ask you again a simple question. Do you believe that Liddell Lee is guilty of the murder and the rapes he was convicted of?
Senator, you're correct. Incomplete and partial is different than inconclusive. They have pretty precise scientific meanings. I don't mean to mince words, but I've been trained by scientists, as many lawyers are not, to be careful in the use of those terms. I do continue to represent Mr. Lee's sister, and it would be unfortunately, I cannot, in my role as an attorney, comment on the merits, and certainly on my former client's guilt or innocence. I can tell you that there is a significant amount of compelling evidence in favor of his innocence. We would not have taken the case if it were
Compelling
not.
evidence that court somehow overlooked for 22 years until he was executed?
Senator, I have represented many individuals who were exonerated by DNA who lost dozens of appeals in courts because DNA was not available, and eyewitness identification, which you reference, is actually the single leading proven cause of wrongful conviction. So certainly some of those convictions are rightful ones, some are wrongful, and we have learned that it's through DNA that we can...
Hawley Lodge-Meyer is the prosecuting attorney who tried this case. She was a prosecutor for 27 years. It was the only death penalty case she ever pursued because it was so heinous. Do you think you know better than she does about Liddell Lee's guilt or innocence?
Senator, I'm sure that Ms. Lodge worked very hard to pursue what she thought was a just result, as have many prosecutors who, through no fault of their own, ended up wrongfully convicting innocent people. And I think what we can hope from our system is that all of us as human beings will take an open and fair look at the evidence, including new technology that was not available to Ms. Lodge.
As he walked to the execution chamber on the night of his execution, he looked at the warden and smirked and said, "This ain't happening, y'all are taking me back." Are you proud that you encourage such defiance in convicted murderers?
Senator, I don't believe that anything in my career has ever encouraged defiance or disrespect for the process, and I know that Mr. Lee maintained his actual innocence until his execution.
Would you like to say anything today to Deborah Reese's family?
Thank you, Senator, for that opportunity. There is no question that Ms. Reese suffered a horrible death that no one in this world should suffer. And my heart goes out to her and her family for their loss. And I only hope that the right person was convicted and executed, because the contrary is unimaginable.
Anything you'd like to say to the 3 women who Liddell Lee raped?
Senator, I can tell you that he did maintain his innocence of those offenses as well, and I certainly do not in any way intend to disrespect what they went through. I have known and worked with many survivors of sexual assault, some of whom are very dear to me, and what they went through is unimaginable, and I hope our justice system will always do what we can to get it right in those cases.
Thank you, Senator Cotton. Senator Whitehouse.
Thank you, Chairman. Let me just open by saying that I've been the U.S. Attorney for my state and the Attorney General, and Rhode Island is one of the states where the AG has full criminal jurisdiction. There are only 3. So I've been involved with prosecutions for a long time, and I want to say that in both of those offices, we viewed capable, determined defense counsel as a real asset. We were proud to be part of a process for adjudication, and we understood that effective representation for the individuals who we were prosecuting was a vital part of the system. In fact, we looked to the defense bar for hires from time to time. It's not, war of prosecutor against defense. It's a joint mission to a process that the world looks at and can be proud of. During the course of my time as Attorney General, it became apparent that we had in jail a person, indeed a police officer, previously convicted of murder, who was in fact actually innocent. And we discovered that because the actual murderer had a crisis of principle and came in through a lawyer to confess. We found out about this, I want to say, on a Thursday evening, if I remember correctly. And we worked with the lawyer through the weekend to double check the allegations of the new confessor. Because as you know, from time to time, people confess who aren't actually guilty. I don't know why they do it, but it happens. So we had to eliminate that prospect. We were in court the following Monday to explain to the judge what was going on, and at a hearing the following Wednesday, the police officer was released from prison and returned to his life. So I have lived the experience of innocence. Nothing was done wrong by the state's prosecutors in that case. The evidence led them and the jury in a particular direction, and the actually guilty party was not known. So I just want to say that I appreciate the work that you've done to pursue those after post-conviction innocence claims. It really made a big difference to this police officer's life in Rhode Island. You have Ms. Morrison, you have 2 very complimentary letters, one from the Republican district attorney in Tarrant County, Texas, and the other from the senior vice president for legal studies at my frequent nemesis, the Cato Institute. Could you explain a little bit how Ms. Wilson and Ms. Neely came to have this experience of you that caused them to write these 2 very complimentary letters? And could I ask that the 2 letters be made a part of the record?
Thank you, Senator Whitehouse. And I do remember the case in Rhode Island. The exonerated man, Scott Hornoff, is someone I know well, and how commendably your office responded when that very unexpected and truly miraculous confession from the real murderer came in. In terms of the letters you referenced, I worked with Criminal District Attorney Wilson on a reinvestigation of a murder case over the course of many years on behalf of a client of mine named John Nolly. She is, as you noted in her letter, a Republican former judge, and had a real commitment to seeking the truth and doing justice in that case. And I worked very productively with her staff and with her personally over the course of 4 years until she went to court and dismissed charges against my client on the grounds that he was actually innocent. And Mr. Neely from the Cato Institute and I came to know each other through our shared work on prosecutorial accountability and reform. We are people from very different backgrounds, but share a common commitment to due process, and I'm proud to consider him a colleague.
And in your view, is it tough on crime? Does being tough on crime include convicting the innocent?
No, Senator, it does not.
And given that we've had experience that people who are actually innocent have in fact been convicted, we've seen it over and over, and Officer Hornoff was an example in Rhode Island. In terms of being tough on crime, does anything about being tough on crime require overlooking evidence of actual innocence by somebody who's been convicted and incarcerated?
No, Senator, it does not.
Well, I just want to thank you for your work in this space and appreciate very much that you are a nominee, and I look forward to supporting your and all the panel's confirmations.
Thanks, Senator Whitehouse and Senator Black.